Good afternoon, everyone. Welcome to the Assembly Committee on Commerce and Labor. Mr. Secretary, will you please take the roll?
Assemblywoman Carlton. Here. Assemblywoman Considine. Assemblywoman Dickman.
Here.
Assemblywoman Duran. Here. Assemblyman Flores. Assemblyman Frierson. Assemblywoman Hardy. Here. Assemblywoman Kasama. Here. Assemblywoman Martinez. Present. Assemblywoman Marzola. Here. Assemblyman O'Neill. Here. Assemblywoman Tolles. Here. Chair Howdigi.
Present. Thank you so much, Secretary. If you would please mark the members absent excused who are not present, and then mark them present as they arrive. Good afternoon, members, those joining us on Zoom and those here with us in person today. We do have a short agenda, and I think everyone is familiar with our housekeeping items, so I'm going to go ahead and bypass those and jump straight into our hearings for today. We do have two bills, Senate Bill 55 and Senate Bill 295, that will be heard today, and I will be taking those in order. So with that, I will open the hearing on Senate Bill 55, which revises provisions governing the licensing and regulation of employee leasing companies. Good afternoon, Commissioner. Nice to see you.
So good afternoon. It's nice to see all of you in person. I'll just get that out of the way. For the record, my name is Shannon Chambers, Nevada Labor Commissioner. I'm here today to present Senate Bill 55. And to kind of give you a quick statement of what this bill does, let me first say that this is a bill that makes a great deal of sense. This is an issue that has been before this body for about 25 years of how to deal with something called an employee leasing company. So going back in time, there was this thing called the leasing of employees that used to take place that has been replaced now by what are called private employment agencies, which the Labor Commissioner also licenses. So think of a temporary agency like a Manpower, LaborMax. So working with the National Association of Professional Employer Organizations, we came to the realization that we need to come up with a correct and proper term for this industry and to come up with a new definition of what this industry does. So I'll go ahead and outline what the bill does, and then I'm happy to answer any questions that you may have. And I do know that we also have the administrator of the Division of Industrial Relations, Victoria Carrion, on this meeting today as well. Currently, they are responsible for the registration of employee leasing companies, so she is here today too to answer any questions. So first of all, what we're going to do is we are not going to call these entities employee leasing companies anymore. They are going to be called professional employer organizations. This is the terminology that this industry has used for over 25 years. So going back through the legislative history, like I said, this was known going back all the way to like 1995 that the correct terminology was a professional employer organization. So the second thing we are going to do is we are going to define them based on the activities that they are actually doing now. So what these entities are doing now is providing labor compliance services. So for example, guidance on labor laws, guidance on benefits, guidance on other human resources issues. So we are going to add that to the definition of a professional employer organization. We are still going to leave the language in there about the ability to lease employees. However, it will be the goal of the Labor Commissioner to identify which entities are actually still doing that and then transition them to a private employment agency license. So by moving this under the Labor Commissioner will be able to review these entities, find out what they're exactly doing, and then get them in the proper licensure status. So the other thing we're going to do is instead of a certificate of registration, we are going to call it a professional employer organization license. And let me address that issue because this came up on the Senate side of the bill. We are not adding any new requirements. We are not adding any new fees for the license. We are just changing it from a certificate of registration to a license. This is more consistent with what other states have done and more consistent with the industry terminology. So nothing will change. It's just a change in terminology. The Labor Commissioner did explicitly put language in Senate Bill 55 that the license application, if it was denied or non-renewed, they specifically had a right to appeal, so that is new. It is my position that you have a right to dispute if your license doesn't get approved or it doesn't get renewed, so we explicitly put that language in Senate Bill 55. We also changed the penalty structure that was in kind of the previous statutes to a $5,000 administrative penalty that is discretionary at the option of the Labor Commissioner. That is a maximum, so it could be anywhere from 0 to 5,000 at the discretion of the Labor Commissioner. That is also less than the existing penalty structure, and quite frankly, will offer a much more expedited process. The Labor Commissioner's appeal process is typically 30 to 60 days at the maximum. So again, trying to provide some oversight, but also provide some avenues for due process to a professional employer organization should they need that. So with that, Madam Chair, I can go ahead and walk through the main sections of the bill that are going to be changed, and then again, happy to answer any questions. So sections 1 and 1.5, again, we're going to replace the term employee leasing company to professional employer organization. Professional employer organization will now then be part of the entire statutes that the Labor Commissioner then has authority over, so those conforming changes will be made throughout the bill and the statutes once they get codified. We will also add the new definition of professional employer organization to the definition of client company. So the client company that uses what are called professional employer organizations, or PEOs, that definition will also be incorporated into that definition. The Division of Industrial Relations will still retain the enforcement provisions over workers' compensation insurance. That is appropriate. The Labor Commissioner does not enforce the statutes on workers' compensation, so that will stay in the bill. And just for reference, that is the same with a private employment agency as well. The Labor Commissioner does not verify or approve workers' compensation insurance, so that'll still be left with the Division of Industrial Relations. So sections 2 and 3 of the bill, again, as I said, we will change from a certificate of registration to a license and transfer the licensing responsibility to the Nevada Labor Commissioner. The Nevada Labor Commissioner currently licenses private employment agencies, so we have staff who's experienced to review applications, to review bond applications, so this will not be a new process, and there is no request here for additional staff for our office to take on this responsibility. I'm confident that we have existing staff that can do this. So again, I mentioned the right of appeal. If a license was denied or it's non-renewed, a PEO will now have that right. In sections 4, 5, 6, and 7, again, it's moving the licensure authority and then adding the authority for a discretionary $5,000 per violation administrative penalty that, again, would have the right to be appealed by the PEO. So the next section, sections 4.2 through 4.8, sections 8 through 18, and then section 19 just make conforming changes throughout the bill, and then that ultimately will be in the statute. And again, why I said why this bill makes sense is I reached out to the National Association of Private or Professional Employer Organizations and had a very healthy and nice discussion with them about why this is needed and why Nevada probably should have done this 20 years ago. These entities have expanded. There are now 203 of them in the state of Nevada. Of that 203, there's only 3 that actually have physical locations in Nevada, so this is kind of an organization and an entity where you can do business outside of the state. With everything that's gone on in the past year and a half with teleworking, remote working, these entities are providing some very valuable services to employers and to employees. The labor compliance part of this is something that the labor commissioner needs to have jurisdiction over and needs to have the authority to find out what exactly these organizations are doing and make sure it's consistent with Nevada law. I don't anticipate any problems. I will tell you my conversation with the NAPEO, as it's called. We look forward to working together. We think that this is going to be a very healthy relationship and something we can leverage on the labor commissioner side to spread the word to employers about new laws, about new postings, new requirements. So again, I'm not approaching this as that this is an industry that needs to be fixed. This is an industry that just needs to be under the proper regulation and enforcement of the labor commissioner. So I did reach out as well to other organizations, the trade organizations, the chambers. Most of them felt that this was a really, really good idea and belongs with the labor commissioner. So that's kind of where we're at, and I'm happy to answer any questions from the committee. And if Administrator Carry-On would like to add to what I've just testified to, I'd be happy to let her do that as well.
Thank you so much, Commissioner. Ms. Carry-On, would you like to give remarks, or are you here for questions?
Thank you, Madam Chair. I would like to give remarks.
When you're ready.
Okay, Victoria Carrion for the record. I am the administrator at the Division of Industrial Relations. Thank you, Madam Chair and members of the committee. And we appreciate the partnership with Shannon Chambers, the Labor Commissioner, in looking at this and the appropriate place that employee leasing companies should be regulated. So the Division of Industrial Relations is currently responsible for the registration of these employee leasing companies. The fee is $500 annually. We have 203 leasing companies right now, and the actual revenue that we brought in fiscal year 2020 was $114,115. We currently have about 0.4 FTE allocated to this function. It's a compliance audit investigator 2 position that was within our workers' compensation enforcement unit. So that position is really better equipped to do enforcement of workers' compensation coverage and compliance issues, and does not really have the type of expertise needed to review these employee leasing company applications. So it really is a much better fit to have this function under the Labor Commissioner. As Shannon Chambers mentioned, we will continue in our office ensuring that the employee leasing companies have workers' compensation coverage, and failure to comply could result in administrative fines. So that function will remain within our office. And just to help clarify for the committee, we previously did not have any true enforcement authority over the registration requirements. And so if there was an employee leasing company that was not complying, we had to refer the matter to the Attorney General's office. And under the new structure, this would be able to be addressed within the Labor Commissioner's office directly. And I'm available for any questions if you have any.
Thank you, Ms. Carry-On. Okay, we will now go to questions from members. I just want to start really quick just to make sure I understood this correctly. So we're basically taking employee leasing companies and renaming them to professional employer organizations. Then we're changing the registration from a registration to a license, but we're not changing the fee. So that's for issuance and renewal, that's staying at $500. We're just calling it something different. And then we're taking professional employer organizations from the Administrator of Industrial Relations, Division of Industrial Relations, and moving it under the Labor Commissioner. And that's in essence what the bill does.
So, Madam Chair, you're absolutely correct. 3 for 3, trifecta. You're absolutely correct.
Okay, perfect. Okay, so I'm going to jump over to Assembly Member Tolles.
Yes, thank you, Chair. And back in many, many moons ago, I used to work for ADP. Was the regional manager for them, and we always had people who confused us with, employment agencies or employee leasing agencies. But I am curious, though, if we're going to fall right back into that a little bit by looking at the definition under Section 1.5, subsection 4. We are now adding a definition that the professional employer organization means a company which, pursuant to a written or oral agreement intended by the parties to create an ongoing relationship, A, provides labor compliance services for a fee, including without limitation, the management of human resources, employee benefits, payroll, and workers' compensation, and then or, and we get into B. B definitely falls more in lines with the employee leasing, or what we're now calling the new terminology, professional, employer organization. So I'm just curious, by just putting that "or" in there, is it possible that this is now going to be interpreted to apply to those payroll companies? Because that's exactly what we did, right? We sold services to help with payroll processing. We actually added on a human resource component. We added on some workers' comp components with some alliances that we had created with other businesses. And so I'm just wonder if this could be, by having that "or" in there, could this be interpreted to apply to the ADPs, the Paychecks, the Intuits of the world?
So again, Madam Chair, for the record, Shannon Chambers, Nevada Labor Commissioner, and permission to go through you directly to Assemblywoman Tolles.
You can go directly to the members, Commissioner.
Thank you. So Assemblywoman Tolles, thank you for the question. So I think what we're trying to do here, and your points are good ones, we're trying to take the first step to get these under the authority of the Labor Commissioner, these what are now called employee leasing companies, find out what they're really doing, and then determine exactly if we need to transition those companies that are still leasing quote-unquote employees to a private employment agency. But by adding the new definition of professional employer organization, it allows them to provide those labor compliance services, to provide the human resources services. But as the Labor Commissioner, I didn't just want to close the door on those companies that may have contracts out there where they've actually leased employees. But the goal will be to work with all 203 of these entities, find out exactly what they're doing, and make sure they fit either under the private or professional employer organization definition or a private employment agency.
Thank you. Follow-up, Chair? So I do think it would be important, and we may need some clarifying language there, because as it reads right now with that "or," I understand you're trying to capture just those 203 agencies or so, but I think that it could be just, as I'm reading it, and perhaps legal could correct me, I think that this could open the door to incorporate all, and that's quite a large net. I mean, just look at how many people use QuickBooks, right? If we were to interpret that under Intuit or ADP or Paychecks or those others out there, payroll services companies, you might capture a huge portion under the way I see it as it's written right now. Thanks.
No, and again, Madam Chair, for the record, Shannon Chambers, Nevada Labor Commissioner, and Assemblywoman Tolles, I'd be happy to work with legal, and, we're still in the hearing stage right now, not at work session. If there's finer language that might be needed, I'm certainly open to that.
Thank you. Okay. And I'm going to turn to Mr. Quast to see if he wants to jump in or address that, or...
Thank you, Madam Chair. Sam Quast, Committee Counsel. I really don't have too much to add to this conversation. I believe you are right, Assemblywoman Tolles, that if you were engaging in either one of those activities, you would be required to be licensed under that definition.
Madam Chair,
Oh, yes, Ms. Carrion, please.
Victoria Carrion, for the record. Thank you, Madam Chair. I did want to point out that entities like ADP currently are licensed or actually registering as employee leasing companies. So I believe they still would be covered under the new legislation.
Okay, thank you. Members, any other questions? Ms. Kasama?
Thank you so much, Chair. I just wanted to clarify, because the chair had a great summary of what we're doing, just moving over and very similar. But under section 7(2), so that penalty of not more than $5,000, but that is new, correct?
So again, Madam Chair, for the record, Shannon Chambers, Nevada Labor Commissioner, it is new. Under the existing authority, under the Division of Industrial Relations, the potential penalty can be up to $10,000 per violation. So we're bringing this under the Labor Commissioner, and under the Labor Commissioner statutes, typically the administrative penalty provisions are up to $5,000. But it is new. But again,
It's new in this section.
It's new in this section.
But under the previous administrator, there was already the penalty up to $10,000.
Correct.
Okay, thank you.
Mm-hmm.
Members?
Madam Chair.
Oh,
may I
yes, Ms.
also
Carrion?
answer? Thank you. Victoria Carrion for the record. Thank you, Madam Chair. So just to clarify, the only authority that our division had in terms of levying administrative fines was if the employee leasing company did not have proper workers' compensation coverage. Otherwise, we didn't have any authority to levy a fine if they were not registering as an employee leasing company. We were referring those items to the Attorney General's office.
Thank you, Ms. Carrion. Okay, members, any other questions? Seeing none, we will go ahead and move into the testimony portion of the hearing. Is there anyone here in Carson City wishing to testify in support of Senate Bill 55?
Thank you, Madam Chair and committee members. For the record, Brian Reeder with Ferrari Public Affairs, representing the National Association of Professional Employer Organizations. Just want to thank the Labor Commissioner for her proactive outreach to our industry and working with us on this bill, and urge your support. Thank you.
Thank you. Is there anyone else in Carson City who wishes to testify in support? Okay, BPS, could we check the telephone lines for anyone wishing to testify in support?
Yes, Chair, to testify in support of Senate Bill 55, please press *9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 55, please press *9 now to take your place in the queue. Chair, there are no callers or support at this time.
Thank you. Is there anyone in Carson City wishing to testify in opposition to Senate Bill 55? BPS, can we check the telephone line for opposition?
To testify in opposition of Senate Bill 55, please press *9 now to take your place in the queue. Again, to testify in opposition of Senate Bill 55, please press *9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. Is there anyone in Carson City wishing to testify in neutral? BPS, could we check the telephone line for neutral testimony?
To testify in neutral on Senate Bill 55, please press *9 now to take your place in the queue. Chair, there are no callers for the neutral position at this time.
Thank you. And before I go to you for closing remarks, Commissioner, I do want to go back to a question. I overlooked our member who's joining us digitally. So at this time, I'd like to acknowledge Ms. Stickman for a question.
Thank you so much, Chair, and thank you, Ms. Chambers. Just had a quick question about if you could explain why this is a 2/3 bill, because you know, if licensure isn't really different from registration, does it have to do with the penalty structure? Is that what you think might be causing this to require a 2/3 vote?
So, Madam Chair, through you to Assemblywoman Dickman, thank you for the question. So what it is, Assemblywoman Dickman, is there's going to be a transfer of revenue of a little over $114,000 from the registration fees that will be transferred from the Division of Industrial Relations to the Labor Commissioner's budget account if this bill is successful and passes. So that is my understanding of it, and that is why it is in the 2/3 world, and that's basically what I know, so that's what I can tell you.
As far as we know, it's just because we're transferring money, right?
As far as I know, again, Madam Chair, through you to Assemblywoman Dickman, as far as I know, that is the reason.
All right, thank you so much, and thank you, Chair.
Thank you, Ms. Stickman, and I apologize for overlooking you earlier, and I will remember to check in with you for questions moving forward. Ms. Chambers, did you want to give any closing remarks? And actually, before we do that, I do want to check with my legal counsel on that 2/3, if that's okay. Mr. Quast, could you explain to us what your understanding of the 2/3 is?
Thank you, Madam Chair. Sam Quast, Committee Counsel. It's my understanding that the 2/3 is due to the expansion of the definition of professional employer organization. Currently, under employee leasing company, it just regulates companies that lease their employees. Under this new definition, there's new activities that would require persons to get a license. So, therefore, you could possibly receive increased revenue due to the increased number of people that may have to get a license.
And I will also go to my vice chair.
Thank you. So to clarify with legal, they were being registered before, but now we're calling it a license. So it's not necessarily the expansion component, it's the change in how it's ending up in that particular area, because it was a registration, now it's going to be a license. It's moving from one division to another. So it's moving from DIR to Ms. Chambers. So it's new for Ms. Chambers, but it was existing before. So because it's new in this chapter is the reason why it would generate the 2/3?
Thank you, Madam Chair. Sam Quast, Committee Counsel. The change of the name between the license and the registration and the transfer of authority, I do not believe is the reason for the 2/3. It's the expansion of the definition of what actually is being regulated. Currently, employee leasing company, if you're a company leasing employees, then you would be required to be licensed as an employee leasing company under this particular license. Now, we're saying that these companies that provide labor compliance services, which are not currently included within the definition of employee leasing company, would also require to be licensed. Therefore, a person who was providing labor compliance services prior to this would not be required to be licensed under this. And after this, they would be required to be licensed under this and pay the fees.
Thank you so much, Mr. Quast. Okay, and now, Commissioner, I'll come to you for closing remarks.
No, again, Madam Chair and members of the committee, thank you very much. And again, that was what was represented to me as far as the fiscal and the 2/3. So that's why I communicated that to the committee. Just to be clear, all those entities that currently have a registration will automatically, unless they don't meet the requirements, will just roll over to a license. So that is built in here. There are no new fees. There's no new positions. So again, certainly defer to legal counsel on how that 2/3 decision was made. I know that was a discussion on the Senate side of whether it was needed or not, so just wanted to address that. But I would urge support for this bill. Again, it makes sense to bring these entities under the Labor Commissioner, and like I said, I look forward to working with the industry and to really kind of getting this issue where it probably should have been back about 20 years ago when this legislative body was first starting to hear the term professional employer organization and what should we do with employee leasing companies. So again, I would just urge your support, and thank you very much for your time today.
Thank you, Commissioner. And Ms. Carrion, would you like to give closing remarks?
Thank you, Madam Chair, members of the committee. We do appreciate Commissioner Chambers and all her help to find a good home for employee leasing companies. We totally agree that renaming them professional employer organizations and regulating them under the Labor Commissioner is the best course for the state. Thank you.
Thank you. Okay, and with that, I will close the hearing on Senate Bill 55. Next up on our agenda is Senate Bill 295. I do believe that the majority leader is still on the floor of the Senate, but has instructed that Mr. Inglesby and Mr. Mills will be presenting the bill, I believe. Mr. Mills, are you with us on Zoom? There you are. Okay, thank you. Committee, with that, we will open the hearing on Senate Bill 295, which revises provisions relating to industrial insurance. Welcome to the committee when you're ready, Mr. Inglesby and Mr. Mills.
Good afternoon, Madam Chair, committee members. My name's Todd Inglesby. I'm the president of the Professional Firefighters Nevada. First, I'll just go over what the bill does, and then I have some remarks, and then I'll pass it over to Jason in case he needs to add anything, but he will be available for any legal questions regarding the bill too as well. Senate Bill 295 simply clarifies existing law for firefighters, police, heart and lung hepatitis cases where those diseases cause partial disability but cause one not to be able to be a firefighter, police, arson investigator. Such members may elect the benefit for permanent total disability. Thereafter call it permanent total disability, PTD. Note, it is not an actual finding of total disability. No existing law allows any offset or reduction of PPD benefits. Thus, SB 295 is a clarification bill. Existing law allows an insurer to remove PTD if they can show the disability is gone. This bill does not change that rule or statute at all. And then, again, good afternoon, Madam Chair, committee members. My name's Todd Inglesby, representing the Professional Firefighters Nevada. Every day, firefighters put their lives on the line, and the Nevada Legislature has consistently recognized the sacrifices associated with our profession. Part of that sacrifice is the chance of suffering a career-ending disability due to work-related injury or disease. We have recently had an issue where third-party providers of workers' compensation have been ignoring the existing law by denying permanent total disability payments even though the firefighter or police officer can no longer work in their profession. We believe this bill will provide language to help clarify existing statute and prevent these third parties from trying to get out of the disability that we are due. In working with stakeholders on this bill, we have accepted an amendment to help alleviate concerns and narrow the scope of protection, in which you will see reflected in the current amendment and reprint. We appreciate the majority leader for always being a champion for our first responders and bringing this important piece of legislation. I also want to introduce again Jason Mills to the committee, who is also here to answer any questions you may have. We urge your support and thank you for hearing our bill.
Mr. Mills, welcome to the committee. Do you have prepared remarks, or are you here for question and answers only?
Chairman Hadeggy, Jason Mills, Nevada Justice Association. Yes, I have just a short remarks. I wanted to point out, and thank you for allowing me to be here today, and thank the entire committee for your time. I wanted to point out that the amendment that Mr. Inglesby brought up is important because it only applies to police and fire and emergency technicians, heart, lung, and hepatitis claims. These are distinct, separate, and apart from all other types of claims. And why they're so important is one can receive a benefit for permanent total disability even if they're not permanently totally disabled, because the statute says if you have a partial disability, but you've lost your ability medically to continue as a police officer, a firefighter, or first responder, then you're entitled to these PTD benefits due to the damage to your heart, lungs, hepatitis, and the knocking you out of this position of being a police officer, firefighter, arson investigator, emergency responder. Knocking you out of that position entitles you to be paid the PTD benefit. Now, what this law does is it clarifies that existing law that does not indicate that you can remove this benefit if you continue to work in some non-police officer, non-firefighter, non-arson investigator capacity. So, for example, if you were to go to be a greeter at the local Mega Mart or something along those lines, you could continue to work and receive your PTD benefit if you can you still have a heart disease, lung disease, or hepatitis, and you can still no longer be a police officer, arson investigator, or firefighter. Existing law, the same statute that's being amended, existing law says that if the insurer can prove that that disability is gone, then they can remove the PTD benefit. Thus, even with this change being put into effect, if they can show the heart disease is gone, they can show the lung disease is gone, and they can show that that they can become a police officer and a firefighter, arson investigator again because the heart disease is gone and the lung disease is gone, then that PTD benefit would be able to be removed. So this law does nothing to alter or change or amend existing law. It's just clarifying that they can't remove it just because the guy's working at the library on the weekends, or just because he opens up a little business on the side to augment his income because he or she's been knocked out from being a police officer or a firefighter, often prematurely. If you're doing 10 years, 12 years, 15 years, you get knocked out of that position. Your earning potential, notwithstanding receiving these PTD benefits, is still greatly reduced. So they need to be able to add these additional ways to earn income, as long as, again, the heart disease isn't gone or is gone, and they're not practicing as a police officer, firefighter, or arson investigator, and a doctor has said that it's okay for them to do that. Then this bill just simply clarifies that these benefits would not be cut off. And I bring this up because over in the Senate side, much of the discussion was about that this rule is somehow going to change, alter, or amend existing law. And that isn't so true. What it really does is it clarifies existing law. And we have looked at old LCB workups on this for previous chairmen that have concluded the same thing that we're putting to you today through the PFFN and on behalf of myself at the Nevada Justice Association. I'm available for any questions, comments, or that you or any of the members have.
Thank you, Mr. Mills. And Mr. Inglesby, I do have one question. When you're referring to the amendment, are you referring to a new amendment that you're providing to the Assembly, or the amendment that you guys adopted in the Senate?
Yes, the amendment we adopted in the Senate. I just wanted to make sure you were aware in case, just bring that attention. We did work with all the self-insurers to come up with that language to narrow that scope down. And I just want to make sure that's where you are aware that's where that came from.
Thank you. Committee members, any questions for our presenters? I'm going to start with Vice Chair Carlton.
Thank you, and it's been a long time since I've had to look at workers' comp statutes, thank goodness, especially these. But if my recollection is correct, under the PTD that would apply, they're paid at a rate of 66 2/3, is that correct? So they, in essence, take a pay cut because they're disabled.
That's correct.
Madam Chair, Jason Mills on behalf of Nevada. Oh, I'm sorry.
Mr. Mills, please, you can go ahead.
Oh, okay. Madam Chair, through you to Vice Chair Carlton. Jason Mills, Nevada Justice. That's correct. And not only that, it's capped, Vice Chair. Remember that their wages can far exceed the cap. So it caps out at 66 2/3 of their wage, or 66 2/3 of the cap, which is usually for police officers and firefighters much, much higher than the cap is their actual wages. So it's actually more than just saying they're 2/3 of their actual wages. That's correct, Vice Chair.
And Madam Chair, if I may, so I don't remember what the cap is, or if it's the same, if it has changed. What is the cap?
Vice Chair Jason Mills, Nevada Justice. It is currently about $6,000 per month. So the award is just shy of $4,100 per month. And most professional firefighters and arson investigators and police officers in this state that have been on any amount of time typically earn more than $6,000 a month in wages.
Thank you very much. I think it's just good to be able to put some relationship points in this, because not only do they have a heart or lung disease or hepatitis, so they've got a chronic illness, they've lost their job, they've got a pay cut, and now someone wants to decide, well, if they go open up a little side business, they want to take that benefit away. So I just want to make sure that we've got it from start to finish, what's actually happened. And I will say from personal experience, it's not easy to get heart and lung coverage. No matter, you can have a heart attack on the job and they will still deny you heart and lung coverage, and you have to fight for years to get it. So just want to make sure, just a personal point of privilege, I know what that's like going through. So thank you, Madam Chair.
Thank you, Vice Chair. Next, I'll go to Assemblymember O'Neill.
Thank you, Madam Chair, for the time. And thank you, Ms. Carlton, for bringing forth some of the information I wanted to bring forward. I appreciate that. But Mr. Mills, I just have a question, and it may be a little confusing, so give me a second to work with it. Let's say a firefighter or emergency technician, medical technician, or police officer has developed a specialty, whether it's an arson investigation specifically dealing, say, with chemical explosions, a police officer dealing specifically with maybe firearms or violent death investigations. They acquire the PTD disability, they're retired, and the community college wants to hire them on as a professor. Would they be able to do that, or do we lose that knowledge that the state that we have learned or have the capability of continuing with? Is that lost? Doesn't seem appropriate to me. The answer is yes. They're not allowed to teach.
Chairman Howdiggy, Jason Mills, Nevada Justice, through you to Assemblyman O'Neill. We believe that the current law does not allow them to do that already. However, there's been some rulings that have come through the hearing and appeals offices that would indicate that you are exactly correct. No, you cannot do that, according to a particular appeals officer down at the administrative hearing offices, if you did do any amount of work, because that would show that you're no longer permanently totally disabled, notwithstanding that police officers and firefighters are not permanently totally disabled when they receive this benefit under existing law. So the point of this was to clarify that they could continue to do such work like that, teach at the local community college, earn wages, et cetera, as long as they're not engaging in police officering, firefighting, arson investigating, and still have this disease of the heart, lungs, or hepatitis. And what we're seeking to do is to clarify that they can't do that, Assemblyman.
That's what I wanted to clarify. Thank you. Thank you, Chair, for the time.
Yes, thank you, Chair. And first, let me just say that I've always said our firefighters, our law enforcement, you're our first responders, you're our veterans. We talk a lot about benefits for our veterans, taking care of our veterans. I'm a sister of 2 law enforcement officers. I appreciate the risks you put yourself through every day for the public and keeping us safe. So if I understand it correctly, we're talking, and that was a wonderful example that I think Assemblyman O'Neill gave. So the idea here is you have somebody who's on PTD, but they are presumably taking a less risky job, for example, consulting or teaching or what have you, but that's not written into this statute. So is there ever a case where somebody might find themselves in another scenario where they're in a job that they may get injured again? What would happen in that case? Would it be a doubled up workers' comp claim? How would that work? And hopefully that wouldn't happen, but just thinking through the different scenarios, it's not written in there that it's necessarily less risky, just not the same.
Madam Chair, through you to Assemblywoman Tolles, Jason Mills, Nevada Justice. Thank you for that question. The existing law already indicates that there can be no greater than 100% benefits being provided on all workers' compensation claims that one is receiving. So if a person was out on a permanent total disability benefit due to his heart disease, he got knocked out at year 10 because of his heart disease, he couldn't be a police officer anymore, and then goes to work at the local community college or elsewhere, receiving that benefit from permanent total disability, gets injured, the roof falls in during their during their day, and they break their arm. They would be entitled to medical care for the workers' compensation injury that they would receive, but they will receive $0 in any indemnity award because they've already achieved 100% of what the workers' compensation system can provide from a monetary benefit to the claimant. That is existing law and existing statute, and that is unamended and unchanged by SB 295.
Great, thank you for that clarification.
Members, any other questions? Assemblymember Kasama?
Thank you, Chair, and I think this is a great bill. I just want a clarification. So we're saying with permanent disability, it's 2/3 basically. So I think in one of the examples, it's if a person was receiving $6,000 a month, and then with 66 and 2/3, their disability would now be $4,000. And then it gives them the ability to go out and get another job, teaching or whatever it might be. So that's great. So my question is, what happens if they go get another job and now they earn $4,000 and they're getting $4,000 and they earn $4,000, so now their total monthly income is $8,000. That's $2,000 more than what their, in the example, the salary was of $6,000. Is there any reduction if their income is more than what their normal salary or cap would have been? I hope that makes sense.
Madam Chair, yes, Madam Chair, through you to Assemblywoman Kasama. Jason Mills, Nevada Justice. Remember that typically what happens is that the 2/3 is again of the max wage they could be earning. So a firefighter or police officer could earn $10,000 or $12,000 a month with their overtime and other things. And then if this happens to them, they get knocked out of that particular job, and now they're only receiving $4,000 per month from this PTD benefit at current rates. If you were older, your rates would be lower, by the way. So if you were to go out and earn any money or income, current law that this does not alter, change, or amend. Current law does not provide for any offset. It's very important that I bring that up because I think some of the opposition in the Senate was saying that, oh, we do this all the time, we're allowed to do this. There is no statute or regulation or Nevada Supreme Court case law that says that you can offset PTD benefits. Remember, these are PTD benefits for earning additional wages. That does not exist in current law, which is why we were somewhat stunned when an appeals officer did this to one of our police officers down here in the South in making such a ruling. And then, of course, the police and fire unions were rightly upset when they saw the assault on their heart and lung benefits that case stood for. So no, existing law does not allow that to be done, Assemblywoman. And this bill would clarify and codify and make it absolutely clear that law doesn't allow that.
Thank you for the clarification.
Okay, members. Ms. Dickman, any questions?
Not really, but I could come up with one.
Oh, no, it's okay. Just checking in on you. Okay, then at this time, we will go ahead and move into testimony and support. Is there anyone in Carson City wishing to testify in support of Senate Bill 295?
Good afternoon, Madam Chair. For the record, Tom Dunn, representing the professional firefighters of Nevada, as well as my own host agency local, the Reno Firefighters Association and Reno Airport Firefighters Association. We sit here today in support of SB 295, and it's important to recognize that as a police officer or firefighter, if you're diagnosed with heart disease in our profession, you are exponentially higher to have another cardiac event once you're diagnosed with that heart disease. There's definitive data to that. There's NFPA standards that address it specifically for firefighters, that once you're diagnosed with heart disease, it is exponentially higher that you are going to have another cardiac event. And the potential of having a significant event, such as death, is we can't put a number to that. Ms. Carlton, based on your statements earlier, I have a story for you that just happened this past week, and it happened to me in a workers' comp hearing, where the third-party administrator has accepted the claim for for heart disease. However, they are denying the employee permanent total disability because they're saying, well, it's possible that they could take a light-duty job or an administrative job with their fire agency. Well, unfortunately, this fire agency does not have a light-duty assignment for a full-time paid professional firefighter. And that's why that benefit resides in the statute currently, is because you are getting a benefit because you are no longer allowed to work your primary profession, which is either a police officer, firefighter, or arson investigator. So once again, we are in support of this legislation, and I'm here to answer any questions you may have as well. Thank you.
Thank you for being here, Mr. Dunn.
Thank you, Madam Chair, members of the committee. For the record, Rusty McAllister, Nevada State AFL-CIO. We are in support of this legislation. As someone who's worked on firefighter and police officer workers' compensation benefits for over 20 years, I can say that this is a benefit that's needed, or a bill that's needed. It's not been something that's been brought up in the past because some of these third-party administrators have never gone in this direction before. It's not something that we didn't contemplate could happen over the course of time, though. As a matter of fact, years ago, I went through, at the time, Assemblyman Conklin, who was the majority leader of the Assembly at the time, and asked if he could ask the question of LCB about whether or not firefighters and police officers were allowed to, should they choose to take a permanent total disability, even though they were only partially disabled, like the law allows, if they were able to go out and seek further employment later on. The response back from LCB was that under the existing statutes that regular employees or workers that were injured could not, but that the statutes allowed for those workers, police officers and firefighters that had been injured in a heart or lung claim could. And so this is just to try and clarify that, that position that's already been in statute. It's not something that's changed. It's just trying to clarify what's already there so that we don't have hearings officers guessing what may or may not be legal. And with that, Madam Chair, I thank you, and we're in support of this.
Thank you, Mr. McAllister. Is there anyone else in Carson City? Okay, BPS, could we check the telephone line for those wishing to testify in support of Senate Bill 295?
Testify in support of Senate Bill 295. Please press *9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 295, please press *9 now to take your place in the queue. Caller with the last three digits of 555. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Madam Chair. My name is Bill Gardner, BILLGARDNER, and I'm calling representing IAFF 1607 North Las Vegas firefighters. I just want to let you guys know how much we really support this bill. I want to echo everything that Mr. McAllister just said and just ask that you please move this from the committee. Thank you very much.
Thank you for your testimony. Broadcasting, next caller.
Caller with the last three digits of 402. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hi, my name is Ryan Green, RYANGREEN. I'm the Secretary Treasurer for the Professional Firefighters of Nevada, also a member of Local 731 Reno Firefighters and Reno Airport Firefighters. Asking you to please pass this bill through the committee here. It's very important to our members, and we appreciate you taking the time to listen to us. Thank you.
Thank you for your testimony. Broadcasting, next caller.
Chair, there are no more callers for support at this time.
Thank you. Is there anyone in Carson City wishing to testify in opposition? Okay, BPS, can we go to the telephone line for opposition?
To testify in opposition of Senate Bill 295, please press *9 now to take your place in the queue. Again, to testify in opposition of Senate Bill 295, please press *9 now. Chair, there are no callers for, oh, I apologize. One caller just raised their hand. Caller with the last three digits of 835, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Chair, this is Bolton, OKS.
VPS, did we lose our caller?
Chair, he is still on the line. Sir, we are having a little bit of a hard time hearing. If you could repeat it from the beginning, starting with your name.
Yeah. Carrying on there. Thank you, Madam Chair. AB 295 affects a complex statutory scheme where these officers and firefighters are able to choose two different paths to being made financially are only partially disabled. One is vocational rehabilitation and retraining, as normal employees would. The other is in total disability benefits. Hello?
And caller, we did
Hello?
have some difficulties hearing you, so my recommendation would be to submit your testimony in opposition in writing, and we will include it in the meeting record. Okay, broadcasting, if we could move on. Is there anyone else in opposition?
Chair, there are no more callers in opposition at this time.
Okay, thank you. Is there anyone in Carson City who would like to testify in neutral? Okay, BPS, could we check the telephone line for neutral testimony?
To testify in neutral on Senate Bill 295, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 750, please slowly state and spell your name for the record. You'll have 2 minutes and may begin. Caller with the last 3 digits of 750, please press star 6 to unmute.
Good afternoon, Chairperson and ladies and gentlemen of the committee. This is Sean Meng on behalf of NSIA. I'm partners with Dalton Hooks, who was just on the phone but experiencing technical difficulties, and testifying on behalf of NSIA in opposition to the current Bill 295, Senate Bill 295. I'm calling in today just to briefly explain our opposition here. As Mr. Hooks was trying to state over the phone, there's 2 methods for these partially disabled firefighters and police officers to obtain the permanent total disability benefits from the Heart and Lung Bill when they meet the criteria that are suggested in this bill. And that is either they can choose to be vocationally retrained into another occupation, or they can elect to receive permanent total disability benefits, those benefits that are generally reserved for individuals who have been deemed by a physician to be permanently and totally disabled and incapable of employment in any degree. They can elect those benefits. The problem here is that the proposed bill is in essence allowing for those individuals to elect those permanent total disability benefits, forego the vocational retraining benefits that are provided in the Act, obtain payment of these tax-free wage replacement dollars, and then go and double up and get another job, in essence, doubling up the benefits that would be provided under the complex benefits in the Nevada Industrial Insurance Act. This is basically, and even more than that, in addition to doubling up, they can still get their PERS benefits, these retirement benefits, at the same time as all this. So in essence, receiving triple their wages that they received as a firefighter. That creates a huge problem here, of course, and a huge cost to the state and to these local agencies. We would ask that this not pass through this assembly, and that the bill as written be stricken or amended so that exactly what Mr. Mills was talking about, so that the employers, the state or local municipalities, so that they can offset any additional pay and wages by the amount up into the deemed wage from the permanent total disability statute. And with that, we would submit.
And before you jump off the line, we do have a question from you from a committee member. I'm going to turn it over to Vice Chair Carlton.
Thank you very much, Madam Chair. And the connection was bad, so I just want to make sure that I understood correctly. So your point is that because they're currently permanently totally disabled, the classification that we have put in statute, they're getting 66 2/3 of their deemed wage. And your position is because they're getting that, they shouldn't be allowed to take a job someplace else. Now, so in essence, the proposal that I believe you're headed towards is if they take a job someplace else, you don't want to pay them the 66 2/3 anymore. That doesn't mean that they don't have heart, lung, or hepatitis issues. You just don't want to pay them for it. You want to take that benefit away. So the goal is to just remove the benefit, is what I'm hearing. Was that correct?
Not exactly, ma'am. The goal here would be to eliminate the wage replacement benefits that are tied to the permanent total disability statute, and to reduce those benefits by the amount that they have supplemented through their new occupation. So
okay, then that was that. You made it perfectly clear right there. So let's go ahead and stop there for just a second. So the grand bargain in workers' comp is that if you have a worker that has been hurt, you either make the man whole, woman whole, but the old statute was man whole, or you give them the compensation for not being able to go back to their job. These folks can't go back to their job. It has been deemed that they had their jobs taken away from them through no fault of their own because they acquired a disease. So you, in essence, want to penalize them a second time because they go get another job. You want to lower that 60. Now, if they were getting 100%, we might have a conversation. But because they're only getting 66 2/3, you want to lower that amount even more because they went out to get another job to help make up the difference of their pay cut? Is that what I'm hearing you say?
Well, as the law currently sits, ma'am, as the law currently sits, there's two channels at the culmination of this permanent total disability analysis, or this heart-lung bill, sitting out there. One, the individual can choose vocational retraining, or that they get retrained and choose not to receive those wage replacement benefits, but to be retrained into a new profession. Those individuals currently, a large majority of these individuals with the heart-lung bill go out and get retrained into a new career or occupation, and they go forward without these deemed or elected permanent total disability benefits. There's another side, another channel, where that individuals can choose to forego those vocational rehabilitation benefits and instead elect to receive a permanent total disability wage replacement benefit. Those individuals are set up to be deemed permanently totally disabled for the remainder of their career. What's being proposed through this bill is that instead of going through the specific vocational retraining, and instead of those individuals who have elected to go in that direction, that we allow these firefighters and police officers to elect to receive the deemed or permanent total disability benefits, get 2/3 of their wages tax-free, right? So they don't have to pay any taxes in association with this work comp benefit, right? So getting very close to their normal wage, and allowing them to then go and get the same benefits of those who have chosen to give vocational retraining because they secure a second job and double up on their wages, with no effect on the elected permanent total disability benefits. In addition to that, those PERS and retirement benefits.
I'm going to stop you right there because that has nothing to do with the bill. I believe you're bringing in an item that has nothing to do with the bill. Apologize, Madam Chair, but I'm going to continue. Those items have nothing to do with this bill. Those are benefits that are earned for years' worth of service, and those should not be part of the conversation at all. We're talking about an employee who is suffering a chronic illness who elected to take the PTD. And I believe you're getting a little squishy in some of the comments because part of this election choice is whether you want to take a lump sum or the monthly part. And the VOC rehab fits in another component. So a lot of the things that you're saying, if folks aren't thoroughly versed in workers' comp, can be very, very confusing. And that's part of the problem with having folks testify over the phone is it can make it very difficult. But basically what I'm hearing from you is you're saying that if one of these folks has a PTD and is only making 66 2/3 of their wage, you believe if they go get an outside job, that should be credited against that wage. That's the position that I'm hearing from you. Is that correct?
Yes, that's correct.
Okay, thank you.
Okay, and then we also do
I'm
have-
good. Got the answer. I just wanted you to give me an answer. Thank you very much.
And I also have another question from you from Assemblymember Dickman.
Thank you so much, Chair. I was just wondering, since you brought up PERS, if you take this permanent...
I'm sorry,
total-
Ms. Dickman, I'm going to have you take that question offline. This bill does not, PERS isn't a part of this bill, and so I just want to keep our questions to questions regarding Senate Bill 295.
I just wanted to... Okay, so leave out the PERS. When you take this permanent total disability, does this stop at retirement age?
And just to answer your question, no, it does not. Ordinary permanent total disability benefits are generally offset by any retirement benefits. However, in the situation that we're in right here, the suggestion is that there would be no ability to offset these elected permanent total disability
And Ms.
benefits.
Dickman, what I think we'll
by
do is
either
we can
retirement
probably
or
have the
another
bill
job.
sponsors answer that question when they come up back for closing remarks. That might be a question better addressed to the bill sponsors.
Perfect.
Okay, so then,
Thank you.
members, seeing no other questions for this presenter, I'm going to ask BPS to move on to our next caller. And I would like to remind those on the line that we're actually in neutral testimony. I know that the caller called in opposition, and we were hearing testimony in the neutral, so we'll go ahead and move them into opposition. But in this virtual world, I wanted to go ahead and take his testimony. And so, BPS, if we could check to see if there are any other callers in the neutral position.
Yes, Chair. The public line is open and working, but there are no more callers at this time.
Okay, thank you. And at this time, I would like to call Mr. Inglesby back to the table for closing remarks. And Mr. Inglesby, if you would just address the Assembly member's question regarding whether benefits continue at retirement age.
Good afternoon again. Todd Inglesby, Professional Firefighters in Nevada. Again, thank you for hearing this. And I do want to touch on, it does seem the opposition always talking about it's elective. It's elective because we have to sign a piece of paper saying that we will retire out so our PERS benefits and stuff can be kick in based on disability, which has to be in front of the PERS board, or we get terminated from our position and let go, which causes another thing when you can start collecting your PERS retirement, et cetera, if that makes sense, Assemblyman Dickman. But again, it's elective that we have to sign it because we basically get two options. We get told by the doctor who we have to do a physical every year, and the doctor says you can no longer do this job, and then the municipality says, well, we don't want to also take that liability of you doing the job. Even if you want to, we're going to go with what the doctor says. Therefore, your option is to take permanent total disability. If that clears up your question, Assemblyman Dickman, and or Jason, if you want to add anything on that, you can as well.
You got it fine, Todd. That was correct.
Thank you, and thank you for asking the question, Chair.
And again, I just want to thank everybody for hearing our bill. If anybody has any questions, we know it's time. Everybody's working on a lot of hours. I know you guys are extremely busy. You can definitely reach out to me, or I can follow up with you too as well. Thank you.
Thank you, Mr. Inglesby. At this time, I would like to close the hearing on Senate Bill 295. Because we are getting towards the end of the 81st legislative session, and I know there had been some concerns from my colleague regarding Senate Bill 55, that at this time I would like to move into a work session on Senate Bill 295, though, so we can go ahead and get that moving. I'm going to hand it over to Ms. Pasloff-Thomas so she can kind of walk us through Senate Bill 295 work session.
Thank you, Madam Chair. Margie Thomas for the record. We just heard Senate Bill 295, which is sponsored by Senator Cannizzaro and revises provisions relating to industrial insurance, and there are no proposed amendments. Thank you.
Thank you. Oh, thank you. Members, at this time, I would be looking for a motion to do pass. I have a first by Assemblymember O'Neill. I have a second by Vice Chair Carlton. I'm so sorry. Before we go into accept a motion, I want to ask if anyone has a question on the bill before you. Okay, then I'll go ahead and accept my motion from Assemblymember O'Neill, a second from Vice Chair Carlton. Any discussion on the motion? Okay, seeing none, all those in favor, please signify by saying aye. Aye. Opposed?
Aye.
Okay, we have an aye from Assemblymember Dickman. Is that correct?
Yes.
Okay, the motion passes unanimously. Thank you, members. Okay, now, next, I would like to assign that floor statement to Assemblymember O'Neill.
Thank you, Chair. My privilege.
Okay, members, at this time, the last item on our agenda is public comment. While we give those listening over the internet time to call in for public comment, I'm going to see if there's anyone here in Carson City wishing to give public comment. Okay, seeing none. Broadcasting, can we check the telephone line for anyone wishing to provide public comment?
Chair, the public line is open and working, but there are no callers at this time.
Thank you. Okay, and members, we do have a couple more bills that have been sent our way to Commerce and Labor, so we will be meeting Wednesday. I will see you Wednesday afternoon. Thank you, everyone. We are adjourned.